All right, welcome back to the Law and Crime Network. My name is Bob Bianchi. I'll be taking it from 12 to 3. Welcome to our audience. This is a Dan Abrams production. As you know, we cover our trials gavel to gavel. And we have Wisconsin versus Kaylee Fleischauer. And this is going to be the state's rebuttal case. They're in court live now. Let's go to it.
It requires a number of things. In this case, and in all cases of firearm deaths, you have to take the information that's coming from the death scene, wherever that takes place. What the police are telling you or the investigators are telling you what's going on, any explanation of that, plus the autopsy findings. You have to combine them all together. You cannot take any finding separately. You have to combine them as a package. That's what you're supposed to do, is consider the whole gamut of findings.
And in terms of homicide, that would be a killing done by another person, is that correct?
That is the definition of homicide. This is a medical definition, a death at someone else's hand, yes.
And correct me if I'm wrong, is it fair to say that where there were external injuries indicative of a fight, that helps you decide that this was a homicide at the hands of another person?
That is one of the things that raises grave questions regarding the manner of death, yes.
What, if any, role to reasonable degree of medical certainty did the distance of the firearm from Chase Fleischauer play in your decision to concur in Dr. Mills's finding?
It is another component of the external exam or the examination of the outside of the body that causes grave concern. Do all suicides have to be contact wounds? A contact wound is when the firearm, whatever firearm you're using.
Doctor, right now I'm just asking about...
You interrupted.
Right, because it wasn't... I'm sorry, Judge. Objection non-responsive.
Thank you. And Doctor, if you can just answer the question. Mr. Kaiser, question?
And I apologize, Doctor. I asked it wrong. I asked a bad question. It wasn't what I was looking for.
Ask it again.
Thank you. I appreciate that. What, if any, role did the distance that it was reported to you the firearm was found from Chase Fleischauer's body play to a reasonable degree of medical certainty in your decision to concur in Dr. Mills's manner of death as homicide?
It was a grave concern considering the information we were provided.
And in terms of accidental or suicidal self-inflicted injuries, how, if in any way, does the distance of the firearm being found from Chase's body inform your decision about this being a homicide?
It strengthens it.
In your years of experience and years of practicing your specialty, where would you normally expect the firearm to be in a pistol death of either suicidal or accidental self-inflicted injury?
In close proximity to the body.
Doctor, if you would take a look at Exhibit 150 and look at the bottom of page 5 over to the top of page 6 and just read that couple of sentences to yourself, and then I want to ask you a question about that.
All right, sir.
Thank you. Do you recall whether or not you had an opportunity during the time that you were participating with or engaging in internal examination of Chase Fleischauer's skull to see what Dr. Mills was identifying there in the report as being a linear skull fracture?
Yes.
What did you understand her position to be in regards to how that linear skull fracture originated?
Object to that, Your Honor. His understanding is a vague question.
That's fine. I'll ask a different question.
Thank you.
Doctor, if I'm wrong, correct me, but do you recall her conclusion being that the linear skull fracture she describes her opinion being to a reasonable degree of medical certainty that that linear skull fracture did not originate with the gunshot?
That is my understanding, yes.
Did you review that actual fracture in Chase Fleischauer's skull?
Yes.
What, as you looked at it, what factors did you rely on in concurring in her opinion that that fracture did not originate with the gunshot?
Fracture lines from the gunshot appear to arrest at the left parietal fracture.
And what's arrest mean?
Stop.
Stop. And what is it about the fracture lines from the gunshot that causes you to believe that there were those there that stopped at the linear fracture, but that the linear fracture did not originate at the gunshot?
Sequence.
Can you describe that for me for more? What do you mean by sequence?
From the fractures, it appears the parietal fracture preceded the fractures from the gunshot wound.
And is that sequence in part informed to you by the fact that the fracture lines you were able to identify from the gunshot wound stopped at the parietal fracture?
That's what I am saying.
Was there anything else about the location or the angle of the linear fracture at which the fractures from the gunshot stopped that helped you conclude that it did not come from the gunshot?
No, no.
How, if in any way, did that left parietal fracture, linear fracture, which you concurred did not originate from the gunshot, how, if in any way, did that support your concurring in Dr. Mills' opinion that this was a homicide and not a self-inflicted injury?
Object to that, Your Honor.
Basis?
I will withdraw the objection.
Thank you. You can answer, Doctor.
Ask it again.
I'll ask the court reporter to read it back.
Question: how, if in any way, did that left parietal fracture, linear fracture, which you concurred did not originate from the gunshot, how, if in any way, did that support your concurring in Dr. Mills' opinion that this was a homicide and not a self-inflicted injury?
The answer?
You can answer.
Suggests that there was prior trauma where the fracture was there prior to the gunshot wound.
Given what you saw of that fracture, Did it appear to you to...
All right, state's rebuttal witness there, the ME. We have with us in studio the magnificent, the great, the ever-talented legal analyst and part-time host every now and again here at the Law and Crime Network, Julie Rendelman is with me. Hello, Julie.
I think people are wondering who they were going to see after that speech, but thank you.
Julie's the best. I have so much regard for her and her legal opinions, and I love following her on Twitter as she debates the legal points, always to great skill and efficacy. And of course, we have with us another crime analyst here at the Law and Crime Network, the great Gene Rossi. He has trained over 1,000 prosecutors at the DOJ, over 100 trials. He's a great basketball player, a great guy, a great legal mind. I couldn't have two better here at the network. Welcome, Gene.
Thank you.
The only debate we have with Gene is that I don't like polenta and he does, and Linda Kenny Bodden and him are ganging up on me. Nevertheless, what do you guys think about this, ME? Julie, I'll start with you. Is it an accident or is it a homicide? What's happening?
So now we're now forgetting about everything else, and it's become the battle of the experts. And to me, when there's a battle of the experts, it usually rules in favor of the defendant because the jury's left going, do we have a reasonable doubt? And I think that's kind of where we're headed in this direction. But
Gene, I don't disagree with that. I've said that before in cases. In OJ, for some reason, when Julie said that, popped to the top of my mind, where they put so much of their eggs in the basket of the DNA. And a lot of times expert testimony is complex, especially if it's contradictory by credible people. And the jury tends to want more. Like in OJ, I never understood why they didn't have show the jury the drive in the white van with Al Cowlings and the ski mask and the $10,000 in cash. That's not consistent with innocence. What do you think about Julie's point of view?
Oh, I think Julie's absolutely right. When you have two experts, they go into the deliberation room, and if the experts are credible, you are going to have reasonable doubt. You'll have a hung jury or a lesser included offense. But I have to emphasize, if the experts are relatively and equally credible, and I didn't see the expert that was called by the defense, but I will go to this issue. The motion for a new trial was based on a juror doing a dog test to see if a dog could move the rifle the 10 feet. So the placement of the gun is like the key issue in this case. How did the gun get 10 feet away from Chase the son? That's the issue. And if an expert gives them a rational explanation, you could have a hung jury, an acquittal, or a lesser included charge.
Yeah, that's definitely a very good point, Steve. Okay, listen, we got a lot going on here on the plate today here at the Law and Crime Network. I got the two great legal analysts here to help us out. We're going to take a quick break here, and we'll be right back. Stay with us.
I'm Aaron Keller. Here are the criminal trials we're bringing you live as they happen on the Law and Crime Network. Wealthy real estate heir Robert Durst is being tried on charges he killed his friend Susan Berman.
Maybe I wanted to get caught.
Because she knew he killed his wife, Kathy Durst.
I think he doesn't want to kill, but he doesn't like to be told no.
Plus, the case of a Wisconsin man accused of shooting his son in the head. He says it was a shocking accident. Join us on the Law and Crime Network for live, unfiltered coverage.
I'm Dan Abrams, and this is the Law and Crime Network.
His body just went boom.
She did it! The only 24/7 network with expert legal analysis and gavel to gavel live trial coverage.
He kissed me goodbye on the cheek. That was the last time we saw him.
From high-profile cases to the most compelling local trials.
You didn't expect her. Let me finish.
We cover the most interesting and important legal news going on across the country.
A verdict in the case of an Ohio woman who took the stand and admitted she shot and killed her military husband.
And our multi-platform brand is resonating. From syndication.
With more, we're joined by Law and Crime Network host Jesse Weber.
To our expert analysis.
With me now is Rachel Stockman, editor-in-chief for Law and Crime Network.
This former head prosecutor, criminal defense attorney, and host of Law and Crime Network, Bob Bianchi.
On Monday, the Law and Crime Network covering the trial live.
With dozens of places to watch, we already have tens of millions of minutes viewed per month. And our viewers and readers are engaged. With more than 30,000 comments per month on the site, a bustling chat room, and an average watch time of 30 minutes.
Womanizer, that's fine. It doesn't make me guilty of solicitation of capital murder.
We got a lot of fascinating cases, as we always do, gavel to gavel coverage.
In the fastest growing genre in America, we are uniquely positioned to dominate. This is Law and Crime.
If you're talking, they will hear you every single time.
Oh, we're getting killed.
Yeah, well, Kyle's not here.
How come?
Kicked off the team. Didn't Tim tell you? Kyle and some other kids got caught drinking beer in the park a couple of nights ago.
Really?
Yeah, 0 tolerance. He's out for the season.
Come on, it's a first offense, right?
That we know of. But why should that matter? He knew not to drink. I've made it clear to Matt, that's what we expect from him. What have you said to Tim?
Nothing really. You know, a lot of kids try it at this age, so.
Yeah, well, a lot of kids don't try it too. I'm not saying that Matt's gonna be this perfect kid, but if I don't tell him what we expect and why he shouldn't drink, how's he gonna know?
You think kids that age really listen?
They never admit it, Bill, but they hear more than you think.
Talk. They hear you. For more information about talking with kids about underage drinking, visit underagedrinking.samhsa.gov.
When I was a kid, I wanted to be just like Cal Ripken. It's definitely humbling to know that now people are calling me a hero. Instead of finding the IED with my metal detector, the IED found me first, and that resulted in double above knee amputations. It's hard to describe the feeling of meeting somebody that you've always wanted to be like. There are people now that are looking up to you for their inspiration and to be their role model.
Visit saluteheroes.org to learn more.
All right, we're in the rebuttal case, and the state's medical examiner is now being cross-examined by the defense in the Fleischauer case. Let's go to court.
3 lines down, there are two 1 3/4 inch red contusions, abrasions on the back of the right index finger, and that'd be the trigger finger, correct?
True.
And 1/8 inch cut on the right ring finger, correct?
Correct.
And 1/8 inch abrasion on the back of the right hand. Well, forget the back of the right hand. The injuries to the finger, that in a reasonable degree of medical certainty could be consistent with accidentally firing that gun and the gun flying out of your hand, correct?
That is one possibility, yes, sir.
And you also learned that there was no gunshot residue on Cale Fleischauer from his testing, correct?
That is our understanding, yes, sir.
And you also learned that the DNA in the case, there was DNA in the pistol, correct?
Yes, sir.
But there was, from the experts or from the people out in Madison, they did not test for blood on the gun.
All right.
But why they didn't, apparently, was why they didn't see any blood on the gun, correct?
Yes.
There was, however, DNA of Chase Fleischauer found on the barrel of the gun, correct?
Correct.
And with respect to the GSR, if Cale Fleischauer, if there's no evidence he washed his hands between the time he was handcuffed and the time that the nurse took the swabs, that would be an indication to you that he wasn't around when the gunshot was fired, correct?
True.
Now, with respect to the distance of the gun, you testified prior, and you testified today that in an ordinary situation for suicide, somebody intentionally shoots himself, the gun lands 1.5 feet or underneath the body, correct?
In most cases, yes.
And accidental shootings, is it your testimony that that's also true in accidental shootings?
If no one is, if the gun isn't inadvertently moved, yes.
Okay, well, have you reviewed or seen the testing of Corey Burton and the recoil of this pistol?
If we're referring to the same thing, I've seen part of it, yes.
Well, have you seen the testing where the gun flew, when it was held, the gun flew up to 10, I think 12 feet?
Yes.
And if the gun, and have you seen the video of the recoil of this gun held by, I believe it was Detective O'Keefe? Did you see that?
I did not see that. I only saw the one using the inanimate object.
Okay. And that recoil, you saw that, you agree that if the gun was fired as it was, that the gun would fly back up to 10 feet.
Objection calls for this witness to make a conclusion regarding...
Sustained as to the form of the question.
Well, you did see those, correct?
Yes.
And that does not change your opinion at all?
No.
So even if somebody accidentally shoots that gun, looking at it, and it goes off, you're saying that the gun would still land right down below?
In most cases in our office, in those situations, yes.
No, but not in all cases.
I cannot sit here and tell you every case, it's always going to be the same. No, I'm not going to say that. I can only tell you that.
Excuse me, when was the last time you had a case where there was an accidental gunshot?
Last week.
Okay, and was the person who did that, was it self-inflicted?
You're talking about accident or suicide?
Talk about accident.
Well, accident would be sometime in 2019. It wasn't last week, but it was in 2019. I'm sure we must have had an accidental shooting, sure.
Well, you don't remember it though?
I'm sorry, sir, I don't.
No, okay. But was that a self-inflicted?
It was, yes.
So in that case, the person holding the firearm shot himself?
Yes, that's our understanding, yes.
You agreed, do you know about the unspent shell casing in the living room found in this case?
I don't believe I can answer that, no.
You're saying that the injuries on Chase Fleischauer enter into the whole picture as to whether or not this was homicide or suicide, correct?
Yes.
What's all of the other factors I just mentioned, the gunshot, at least you saw the video of the gun flying, the DNA, the GSR, none of that causes you to rethink your homicide?
No, sir.
And you mentioned the injuries that played a part of this. Now, you're not talking about the injuries having a motive for the person that's deceased holding the gun. You're talking about the injuries of the deceased being shot by somebody else because he has these injuries. Is that what you're saying?
No, I don't think that's what I'm saying. What I'm saying is the presence of the injuries suggests that that's something that we normally do not see on suicides.
We're not saying this is a suicide, sir. What I'm asking you is, oh, okay, I'll withdraw that. So what you're referring to here is if a suicide, you don't normally see those injuries.
That's right.
Okay. And it would be consistent, would it not? Withdraw that. Give me a second. Did you see any other videos or any other demonstrations of this pistol recoil flying somewhere?
No.
And did you bring your notes with you with respect to viewing the inside of the skull of Chase Fleischauer?
There are no notes, sir.
No notes?
No notes, sir.
No notes of Mills either? Is that it? Dr. Mills?
I don't know if Dr. Mills took notes or not. You'll have to ask her.
Okay, and you didn't take any notes, though?
No, sir.
And you've done many autopsies since then, correct?
Yes, sir.
And many before, right?
Yes, sir.
One second. Thank you, Doctor. I'm done.
Thank you. Mr. Kaiser, any redirect?
Couple of things, Judge. Thanks so much. Dr. McGee, how in any way, into a reasonable degree of medical certainty, do the external injuries Chase Fleischauer suffered distinguish this case from other accidental shootings that you've examined?
If they do, Your Honor.
If they do, that's fine.
Thank you.
Generally speaking, accidental self-inflicted gunshot wounds have a minimum of additional injuries.
Have you seen other cases where persons have been in a fight and been shot?
Yes.
Can you think of any of those that weren't, based on your training and experience and the autopsy itself, as well as the investigation, ruled a homicide?
All right, so let's talk a little bit about the cross-examination of the state's rebuttal expert, the medical examiner. We were talking earlier about experts, Julie, and one of the ways that at least I go about cross-examining experts is you don't want to get too deep into their science because that can be a fool's errand because they know a lot more about it than you do, but attack the things that they may have disregarded in the case or that they're not letting it change their opinion. And the lawyer did a pretty good job, in my opinion, bringing out the gunshot residue issue, the DNA issue, not having seen all of the video evidence and disregarding the one that shows the gun with the recoil going back significantly. Either he didn't take that into his opinion, it didn't alter his opinion, or he didn't see it. That's always a good avenue, in my opinion, for cross. What are your thoughts?
Yeah, and I don't know if I was missing it. Did he not take notes of what he had done, which he brought out that he had done multiple autopsies both before and afterwards to establish that he may not even have a good memory. One of the things that I also thought stood out to me is it almost seemed like this medical examiner was confusing the issue of someone committing a suicide versus someone having an accident, and so was kind of using what you would expect from a suicide instead of what you'd expect from an accident. No one's claiming he tried to kill himself. They were claiming that it was an accident.
Right, and Gene, that same question goes to you in addition to the one where the defense lawyer did get him to say on cross-examination that he can't say in all cases that the gun would only fall a foot or foot and a half away from the person. That's something I'm betting we're going to hear in summations.
Oh, absolutely. And he brought out a bit of reasonable doubt. He said there is a possibility of the gun flying out of his hand. In other words, the victim, Chase, had the gun. For some reason, he shot himself by accident, but that flew out of the hand, and it's a possibility that's how it got 10 feet away. That's reasonable doubt right there.
Okay, interesting. And we will have to definitely discuss the tactical decisions, having the defendant taken the stand in the first trial, not taking the stand in the second trial. We will get to that. I want to address Zenny9 from our chat room, who asked the general question, who thinks he's guilty? I'd say an overwhelming majority of our chat room people that follow this case and are, I think, the second jury, as I always say, overwhelmingly support a conviction in this case. Very interesting. We'll take a break. We'll be right back.
I'm Dan Abrams, and this is the Law and Crime Network.
His body just went boom.
She did it!
The only 24/7 network with expert legal analysis and gavel-to-gavel live trial coverage.
He kissed me goodbye on the cheek. That was the last time we saw him.
From high-profile cases to the most compelling local trials.
You didn't expect her to finish.
We cover the most interesting and important legal news going on across the country.
A verdict in the case of an Ohio woman who took the stand and admitted she shot and killed her military husband.
And our multi-platform brand is resonating. From syndication.
With more, we're joined by Law and Crime Network host Jesse Weber.
To our expert analysis.
With me now is Rachel Stockman, editor-in-chief for Law and Crime Network.
This former head prosecutor, criminal defense attorney, and host of Law and Crime Network, Bob Bianchi.
On Monday, the Law and Crime Network covering the trial live.
With dozens of places to watch, we already have tens of millions of minutes viewed per month. And our viewers and readers are engaged. With more than 30,000 comments per month on the site, a bustling chat room, and an average watch time of 30 minutes.
Womanizer, that's fine. It doesn't make me guilty of solicitation of capital murder.
We got a lot of fascinating cases, as we always do, gavel to gavel coverage.
In the fastest growing genre in America, we are uniquely positioned to dominate. This is Law and Crime.
Can I give you a hand?
Our son Arjun was born with cystic fibrosis. CF is a genetic disease that shortens lives. When the foundation was founded in 1955, children with CF rarely lived long enough to attend kindergarten. Today, thanks to the foundation's groundbreaking research, advocacy, and care, some people with CF are attending college, getting married, and starting families. We've made amazing progress, but until a cure is found for all people with CF, we will not stop. Help us add tomorrows. Visit cff.org today.
Okay, we still have the medical examiner on the stand, the rebuttal state's witness. Let's go to court.
Given that close proximity, hypothetically, to a reasonable degree of medical certainty, could that close proximity explain Chase Fleischauer's DNA on the barrel of the pistol used about a half an inch inside the barrel?
Object to that, Your Honor. As evidence it's not in evidence, a half an inch in the barrel, that was never testified.
Sustained as to the form of the question. Yeah.
Okay, sidebar. So, Julie, what are your thoughts here?
I'm a little confused. So I think what he's saying is that the GSR that's on both hands of the victim supports his theory that the victim was shot by the defendant, not by himself. And I'm still not fully, there's another question. I'm curious what the answer is, so I can understand better why that would be more establishing that the defendant did it versus himself.
Well, maybe we'll get an answer because we're back in court.
In your experience, based on your training and experience, as to the effects of a gunshot wound on the human skull, would you have an opinion to a reasonable degree of medical certainty whether, given the proximity of Chase Fleischauer to where the bullet left the pistol, that it may have caused DNA to be present on the barrel of the pistol close to where the bullet comes out of the gun?
Object out of his realm of knowledge, Your Honor, and foundation. He's not an expert.
Well, based on your training experience, doctor, and this is all, again, all these questions asked by the state have to be to a reasonable degree of certainty in your field. So with that foundation, if you have an opinion, you can state it.
My opinion is it possible? Sure, it's possible, assuming the gun is close enough. That's about as much as I can say.
Yeah. So if the testimony in the case has been that the gun was about 5 or 6 inches away.
Is that possible? Yeah, yes, I imagine it's possible, yes.
I don't want your imagination, though, to a reasonable degree of medical certainty.
Now, I don't say that I cannot sit.
Well, please, there has to be a question followed by an answer. And doctor, again, you can't testify to what's possible. You can testify to what's medically probable within your field. So with that, again, that foundation, Mr. Kaiser, the question.
Okay, with that, no, I can't.
Now, you characterize the object in the video recording that you watched as an inanimate object. You remember testifying about the inanimate object in the recording?
Yes.
What was it about how that production was done that causes you to a reasonable degree of medical certainty to find that it does not change your opinion regarding whether or not this was a self-inflicted injury or a homicide?
Excuse me, Your Honor, I object to that because he stated he watched portions of it. He didn't watch the whole thing.
Well, as to those portions you watched, do you have an opinion?
Of the portions that you watched?
Yes, I have an opinion.
And what is your opinion regarding how, if in any way it does or doesn't affect your opinion regarding the manner of death?
It was done with a non-human subject. What I saw was a non-human subject, and I'm not sure that you'd have the same response.
What is it about a human subject holding the pistol that affects the response of the firearm?
I think a hand is different than the object I saw holding the weapon in the video.
Thank you, Doctor. No further questions, Your Honor.
Thank you, Mr. Gray.
Thank you. I neglected to mention, when you're taking everything into consideration here, you also were aware in determining that it's a homicide and not a self-inflicted accidental gunshot wound, that Chase Fleischauer was sitting on a stool, correct? You knew that.
Objection. There's no foundation for it in the record.
I'll sustain as to the form of the question.
Well, Your Honor,
Well, again,
hypothetically, in this case, Investigator Stalkey came to the opinion, because Chase's feet were inside of the stool, that he was sitting on the stool at the time that the gunshot went off. All right? Assume that.
All right, sir.
Okay. Now, assume also that while he's sitting on that stool, he's got a .278 blood alcohol count. Okay?
All right.
Objection outside the scope.
Pardon me? Well, I'll move the...
let's ask the question, Mr. Gray.
That Chase Fleischauer at that time had a .278 blood alcohol count.
Right.
And you knew he was 19 years old, correct?
True.
And did you know that the unspent cartridge in the living room was from that gun? Did you know that?
No.
And while sitting on that stool, he had a .278. What is a .278? What does that mean?
Objection asked and answered outside the scope, not by this witness, but it's cumulative at this point.
Overruled. You can answer, Doctor.
It's an elevated blood alcohol.
it's over 3 times the amount that you cannot drive with, correct?
In Minnesota, that's correct.
In addition to that, it's in a 19-year-old youth, correct?
Also true.
Which also affects your observation of the situation, correct?
Yes, sir.
And then we go to the GSR, the gunshot residue, and you say because there's gunshot residue on Chase Fleischauer's hands, that strengthens your opinion that he was shot by somebody else?
In this case, yes.
And he could also hypothetically, or assume that gunshot residue on his hands were from holding the pistol and it accidentally going off, correct?
That is a possibility, yes, sir.
Well, is it a possibility, or is it as much a possibility as somebody else shooting him? Are they both equal?
No, I would favor in this particular case, it would be from someone shooting him.
And that's from the injuries he had prior to this?
Coupled with the injuries.
And you're basing that on the injuries he had prior to this? Is that what you're saying?
Coupled with them, yes.
What's coupled with them? What else is
Taking them all together, sir. All
What
the
else
injuries,
is there?
the injuries, the GSR, the entrance gunshot wound, all taken together.
3 to 6 inches is a gunshot space.
Right.
31-inch hands could easily shoot himself, correct?
That's true.
Okay. And it is true that, let's see the date on it. Did you have, withdraw that question, Your Honor. And that anything about the temporal bone, that wasn't mentioned in this autopsy.
Now we're outside the scope, Judge.
All right, welcome back. Gene Rossi, I heard Rendleman's breaking the studio up, so don't let that distract you, Gene. That there is something that's bothering you about some of these questions. What are they?
You, Julie, and I have all been prosecutors. And I'll guarantee you didn't make objections like a jack-in-a-box. That's number one. And don't make objections that are going to be overruled. And beyond the scope is usually overruled. Asked and answered is usually overruled. A judge will bend over backwards to give the defense some leash. But it also does a more important, devastating effect to a government's case. You act like you're hiding something, okay? I got to criticize the defense attorney, because Julie mentioned it too, is he got his answer and then he asked another question that diluted the good answer that he got. And that's one question too many syndrome.
Yeah, it gets. I always used to say it goes down to my axiom of all law: when you stand well, stand still. A judge told me that when I was trying a murder case and got a great ruling and continued to argue, brought me in. He said it in a little bit more salty language, but you know, Julie, I don't disagree with that. Yeah, it's not made for a friendly TV audience.
Yes, yes.
So no, it's tactical here. So what are your thoughts about that? And you know, sometimes less is more.
So, I mean, the issue here is he got the expert to say it's possible, and that possibility would indicate an accident and not a homicide. And so then he took it one step further and he said, well, which is more likely? The scenario I gave you or the scenario the prosecutor gave you? Well, he's the prosecutor's expert, so of course he's going to say the prosecutor's is more, you know, it's a ridiculous question. But I'm not going to call him out because we're all watching him. We've all made mistakes. I'm sorry, we are calling him out. I'm not going to call him out that badly because, you know, we all make those mistakes and we often ask one too many questions.
Yeah, when you stand well, stand still. Folks, we got to take a quick break. I hope you stand well and stay with us. We'll be, as Julie Rendleman breaking the studio up again, we'll be right back to piece it together.
I'm Dan Abrams, and this is the Law and Crime Network.
His body just went boom. She did it!
The only 24/7 network with expert legal analysis and gavel-to-gavel live trial coverage.
He kissed me goodbye on the cheek. That was the last time we saw him.
From high-profile cases to the most compelling local trials.
You didn't expect. Let me finish.
We cover the most interesting and important legal news going on across the country.
A verdict in the case of an Ohio woman who took the stand and admitted she shot and killed her military husband.
And our multi-platform brand is resonating. From syndication
With more, we're joined by Law and Crime Network host Jesse Weber.
to our expert analysis.
With me now is Rachel Stockman, editor-in-chief for Law and Crime Network.
This former head prosecutor, criminal defense attorney, and host of Law and Crime Network, Bob Bianchi.
On Monday, the Law and Crime Network covering the trial live.
With dozens of places to watch, we already have tens of millions of minutes viewed per month. And our viewers and readers are engaged, with more than 30,000 comments per month on the site, a bustling chat room, and an average watch time of 30 minutes.
Womanizer, that's fine. It doesn't make me guilty of solicitation of capital murder.
We got a lot of fascinating cases, as we always do, gavel to gavel coverage.
In the fastest growing genre in America, we are uniquely positioned to dominate. This is Law and Crime.
Making was a big part of the foundation of what I wanted my children to do and to have fun with.
Growing up in the Bushnell house was like nutty professor craziness. I know, that's true.
Getting burned on a hot glue gun, that was okay. You know, burning themselves with a soldering iron, that was okay.
I was 6 when I learned how to solder.
We learned how to paint, we learned how to sheetrock, and all these things had such lasting impact.
I felt that creativity would give them entree into being able to do anything they wanted.
Whatever we showed our dad, it was always the coolest thing in the world to him.
Good ideas are very often considered silly at their onset.
And by that definition, we haven't even really grown up, you know? I mean, the projects have just gotten bigger.
We all make and have fun. Now the question is, why do you make?
Share your own Why I Make story today. Visit whyimake.org.
Our son Arjun was born with cystic fibrosis, a rare disease that shortens lives. But there's something you can do to help. Join us as we walk in great strides the Cystic Fibrosis Foundation's National Walk. Every year, thousands of people lace up to raise money and awareness for CF. The CF Foundation has made amazing progress, but we're not done yet. The biggest reason I strive? Because I want Arjun to live a full and happy life. Visit cff.org and sign up for our Great Strides Walk today. Lace up, walk, cure cystic fibrosis.
All right, we have a little break in the action here. So we're going over the Fleischauer case, and this is the battle of the experts, as we said. So we've listened to the state's rebuttal expert. Gives us a good opportunity right now to listen to the defense's medical expert to see what they opine. Let's take a look.
What in your opinion was the cause of death of this?
In my opinion, the cause of death of Mr. Chase Fleischauer was the gunshot wound to the head with brain injury.
And would that be considered the substantial factor of his death?
It would be not only the substantial factor, in fact, it would be the only factor that caused his death.
All right. And did you also come to a conclusion with respect to the manner of death?
Yes, sir.
And what is your opinion with respect to the manner, first back up, what is the manner of death?
The manner of death is the circumstantial explanation for how the cause of death occurred. It is one of the two major elements of what we call certification of death. So when you certify a death, you determine the cause of death, being the disease or injury that leads to the death in an unbroken sequence. And then you also determine the manner of death, which, as I said, is the circumstantial explanation for how it happened.
And do you have an opinion based on a reasonable degree of medical certainty how this incident happened?
In terms of the manner of death, yes, I do, sir.
And what is that?
In my opinion, to a reasonable degree of medical certainty, the manner of death for Chase Fleischauer is accident.
And What do you base that on?
I base that on a number of factors, and again, just as a starting point, I gave you the definition of manner of death being the circumstantial explanation for how the cause occurred. By its very nature, being a circumstantial explanation, the manner of death is highly dependent on circumstances, and you determine circumstances largely through investigation. So I begin with, to answer your question, the basis or bases for my opinion on the manner of death, I begin with the investigation. Investigation, as I understand it, is that we have 3 people in the home that night, Mr. Cal Fleischauer, Mr. Chase Fleischauer, and Ms. Summer Fleischauer. The reports from the people on the scene, the people who were there, were that they go their separate ways to go to sleep, go to bed. Both Cal Fleischauer and Summer Fleischauer report hearing a loud noise. They respond from separate parts of the house to find Chase Fleischauer apparently dead on the floor with a gunshot wound. So the beginning of the investigation tells me that the 2 people in the house who can report the events say that neither one of them was with him when they hear the noise, and then they find him with the gunshot wound.
Okay, so Gene, what are your thoughts about that? I mean, there's the other expert, there's the battle of the experts there, and keeping in mind that the state's rebuttal expert that they called, did the defense lawyer get out the fact that it could be consistent with an accident, although, as we noted, went that one question too far?
I got to apologize. I was a little hard on the prosecutor and the defense attorney, but I like this expert, Dr. Arden. He comes across with a lot more confidence than the rebuttal expert of the government. And what he's doing is he's talking about circumstantial evidence, and he's reaffirming that there's no eyewitness. And if you don't have an eyewitness, circumstantial evidence is the only way you're going to get a conviction. And the theme of this expert is he's trying to cast doubt on that circumstantial evidence. I think he's very good.
Julie, there's always a problem when you put on rebuttal witnesses. You got to be very, very careful, because the jury tends to focus, in for some reason in my mind on those witnesses. The state, it seems to me, is scrambling to prove a point here, and a critical point of their case, and the jury's going to be focusing deeply into this particular testimony.
Yeah, and I agree with Gene. Dr. Arden actually used to be a medical examiner in New York, and he was incredibly well respected. And as you can see here, he comes off incredibly well to the jury. And I don't think, by the way, and I'm going to jump on what Gene said earlier, and I hate criticizing, but that's what our job is. I did not think the prosecutor was even effective with their own witness when they did redirect. They didn't seem to fully understand the questions that needed to be asked to really make this expert clear. And so I was left with a lot of confusion, and to me, once again, confusion brings us to potential reasonable doubt.
Yeah, and part of that is I can't say in all cases. I mean, Gene, what are your thoughts about that? I mean, you could say statistically this is what I see, but I can't say in all cases. As a prosecutor, I want a definitive answer to that question. Could the gun have ejected that far away?
Well, I want to follow up on something Julie said, and I am going back to criticizing the prosecutor. Whenever I had experts on, I always tried to keep the question simple. And when they were doing redirect, when the prosecutor was doing his questioning of his own expert, I was actually closing my eyes and trying to follow his very, 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 very long questions. And I got completely confused. And you can guarantee there are a few jurors that were in my camp. So my main criticism is, with that rebuttal expert, they weren't keeping it simple, stupid.
Yeah, Julie, I mean, that's a good point. You have a battle of the experts that's going on, and the questions themselves, we were asking ourselves, what did he just say? And if we're, as lawyers who are used to this kind of testimony, what is that doing to a jury psychologically? Does that inure to the detriment of the prosecution?
Absolutely. And by the way, it almost seemed like the prosecutor was thrown off by the answers that his expert had given the defense. And we can't be prepared for everything, but he is our expert, so we do expect that there are going to be responses like possibility. Those words are sometimes going to come out, and we're prepared for them. But it seemed that he didn't know how to get him back on track to establish his point that it had to be the defendant that did it and not the victim.
Gene, real quick, and Julie, do you think that this makes a good decision for the defendant not to testify because jurors love to convict? Yes or no? I mean, give me a real quick. I got 30 seconds.
Defendant should not testify.
Right. He testified in the first case, was convicted. Do you agree, given that this is what it's now focusing on as opposed to his testimony?
He should not be testifying.
Okay. All right. Awesome. I got great guests here on the Kylie Fleischauer case. We're going to be doing a lot more of that breakdown, some other matters that we have on the table. Stick with us. You're at the Law and Crime Network.
I'm Dan Abrams, and this is the Law and Crime Network.
His body just went boom.
She did it! The only 24/7 network with expert legal analysis and gavel to gavel live trial coverage.
He kissed me goodbye on the cheek. That was the last time we saw him.
From high-profile cases to the most compelling local trials.
You didn't expect. Let me finish.
We cover the most interesting and important legal news going on across the country.
A verdict in the case of an Ohio woman who took the stand and admitted she shot and killed her military husband.
And our multi-platform brand is resonating. From syndication.
With more, we're joined by Law and Crime Network host Jesse Weber.
To our expert analysis.
With me now is Rachel Stockman, editor-in-chief for Law and Crime Network.
This former head prosecutor, criminal defense attorney, and host of Law and Crime Network, Bob Bianchi.
On Monday, the Law and Crime Network covering the trial live.
With dozens of places to watch, we already have tens of millions of minutes viewed per month. And our viewers and readers are engaged. With more than 30,000 comments per month on the site, a bustling chat room, and an average watch time of 30 minutes.
Womanizer, that's fine. Doesn't make me guilty of solicitation of capital murder.
We got a lot of fascinating cases, as we always do, gavel to gavel coverage.
In the fastest growing genre in America, we are uniquely positioned to dominate. This is Law and Crime.
Some things in your medicine cabinet are more dangerous than others. When it comes to prescription drugs, opioid pain medicines can be addictive and even deadly. Keeping unused opioid medicines in your home is risky. Half the people who misuse prescription pain medicines get them from a friend or family member. Over 100 Americans die every day from an opioid overdose, and millions are addicted to opioids. But you can be part of the solution to the opioid crisis. Go through your medicine cabinets, drawers, anywhere you keep unused opioid pills, patches, or syrups, and find out how to dispose of them safely. Visit fda.gov/drug disposal for details and remove the risk of opioids in your home.
As a young girl, I just grew to love using power tools, pouring concrete, and doing things that were scary and loud, and yet I looked around and realized no other girls are doing these things. As I grew up, I realized that girls need to see themselves in that space. Start here. So that's what I set out to do, and I became an educator and a mentor for young girls. No masks down till clear. Making teaches girls how to think of their ideas as important. Go light. It changes the way they think about what they're capable of. If I can fuse metal, what can't I do? Perfect. Look at how good that was. And so I think making for girls is about voice, and that's what's really exciting, because we're building the world we want to see for ourselves. Now I want to hear why you make.
Share your own Why I Make story today. Visit whyimake.org.
Do you know what to do if you're stuck on the railroad crossing? Get out of your vehicle. If a train is not approaching, find the blue and white emergency notification system sign on the traffic signs at the crossing. For help, call the number on the sign and give them the crossing number so they know your location and can alert train traffic. Remember, find the blue and white to save your life.